Court is calling 2024 CR 011467, State versus Charles Loring Wanless. Could I have parties announced for the record? I believe that's for the court reporter. You can just sit it there.
Okay.
All right, could I have the parties announced for the record for the state?
Andrew Harris Salem.
Defense?
Joseph Upheld for the defense.
And are you Mr. Wanless?
Yes, Your Honor.
All right, counsel, have you received all discovery? Did you review it with your client?
I believe I have, Your Honor, and I have reviewed it.
All right, so everyone, no talking behind the court reporter when the court is on the record.
Pause right here, because this is where people often misunderstand plea bargains. A plea deal is not a guarantee. It's a recommendation. The judge can accept it or reject it. And while Charles technically had the right to walk away if things went sideways, most defendants don't. Because once you waive your jury rights, the leverage is gone. So ask yourself, when the paperwork is signed, is the deal really still in your hands or already out of them?
Court will find that the state is in compliance with discovery. Is there any applications in this case?
No applications, Your Honor.
All right, Mr. Wanless, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
No, Your Honor, proceeding in a lesser included criminal mischief greater than $750, but less than $2,500.
I'm sorry, you're whispering.
Proceeding on the lesser included criminal mischief greater than $750, but less than $2,500.
Any objections?
No objections, Your Honor.
All right, so off the record.
Thank
So
you.
since you all are, yes, so if you all are proceeding on that, the lesser included offense, y'all are gonna need to change this to the range of punishment, the misdemeanor range of punishment. So that he can say that he knows it. So if y'all will just put, and you can put it underneath the second paragraph.
I wasn't sure the best way to do that, Judge, but I
Oh,
thought
no,
we may have run into a
You have
problem.
the other,
I mean, this,
you want it on the second page.
well, if you put it on the admonishments,
On here,
yes, just so that he can be aware. And so under that first paragraph, if you'll just put the charge and then put up to 1 year in the Bear County Jail and up to a $4,000 fine. I just want to make sure that you know.
Okay.
And I wasn't
range of
sure-
punishment
And I
is.
wasn't sure the proper way to do it on their paperwork either.
Oh,
Judge.
no
I just
problem.
wanted-
You know, sometimes it's best to use not the state jail felony paperwork,
Mhm.
but to use the other paperwork, and then on that line, just put
And
the
rest
range of
stuff.
punishment. All right, so we're gonna go back on the record. So the state is proceeding on the lesser included offense of criminal mischief as a Class A misdemeanor. Defense, any objections?
No objections, Your Honor.
All right, so Mr. Wanless, the state is proceeding on the lesser included offense. So they're not proceeding on the state jail felony. So your range of punishment is up to 1 year in the Bear County Jail, and it's up to a $4,000 fine. Do you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual?
This exchange may sound routine, but legally, it's critical. The judge is locking in what's called a knowing and voluntary waiver. Translation: Charles is officially giving up his right to a jury, to confront witnesses, and to stay silent, all in exchange for certainty. And notice something chilling here. There will be no live testimony. The case lives and dies on paperwork. No witnesses. No cross-examination. Just reports. Is that efficiency, or is that the quietest way a case can end?
Understanding of the charges against him.
I do believe he is, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Wanless, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
Yes, Your Honor.
Did you understand it?
Yes, Your Honor.
All right, according to the plea, punishment is to be assessed at 199 days. Any objection to the court writing in the words Bear County Jail?
No, Your Honor.
All right, punishment is to be assessed at 199 days in the Bear County Jail. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
Contained in Exhibit 1 and attachments, Your Honor.
And we've had an opportunity to review those and have reviewed them. We have no objections, Your Honor.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney?
Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
With the court's permission, Your Honor, yes.
All right, anything you wish to say on behalf of your client?
Just that he has accepted responsibility for this, Your Honor. He does have 199 actual days in the Bear County Jail. We respectfully request you to follow the plea bargain, give him credit for all time served, and any time and money spent concurring to show the judgment satisfied.
All right, the court will find you guilty. The court will sentence you to 199 days in the Bear County Jail. The court will give you credit for any time served, and the court will show that the judgment is satisfied. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because, do you understand?
Yes.
All right, so we can go off the record. Mr. Wanless, I've read the police report, so I know there are some mental health issues. Have you been on the medications at the jail?
Yes, Your Honor.
All right, so when you're released from the jail, and I'll have the court called over to the jail to make sure that you're not released at midnight, because that's usually what happens. I'm going to see if they can release you during the day. You'll need to make sure that you set up your medications. You understand?
Sure.
So,
I'm gonna go to the Center for Healthcare Services, Your Honor.
yes. All right, make sure you do that. If for any reason something happens and you can't get in the Center for Healthcare Service,
And that's the final door closing. No appeal, no second chance, no arguing later that it wasn't fair. For Charles, the sentence matches a plea, but the consequences are permanent. What started as criminal mischief now includes jail time, waive rights, and a system moving on without pause. The real question isn't whether the process was legal. It clearly was. The question is, when justice moves as fast, does anyone truly feel heard?
or you're lost and you don't know where to go, you can always come back here and we'll make sure that we find a place for you, okay?
Perfect, Your Honor.
All right, good luck to you.
Thank you, Your Honor.